Well, good morning to all of you, and welcome to this AMIC Academy on Political Risk and Violence Insurance, a go-to guide. My name is Ho Yong Luk. I'm the Head of Research at AMIC, and we're pleased to be moderating today's session. And I shall introduce our great speakers from Herbert Smith Freehills Kramer in a bit. But first, in terms of the session today, obviously political risk has been right at the top of the agenda for organizations and businesses in the past 2 or 3 years, even longer. And has led to an uptick in interest as to whether insurance can help. And today we will consider the political risk and political violence policies and explore what these policies cover, how they operate, and the practical issues that can help you to navigate claims. In terms of our learning objectives for today, we'll be looking to, after the session, recognize what political risk and political violence policies cover and how they differ, to identify the triggers for cover under political risk and political violence policies, describe how claims for losses are calculated under these policies, and then also to be familiar with some of these issues that can arise in relation to political risk and political violence claims to allow you to navigate all these in practice. I'm delighted today, as I said, to be joined by two speakers from the law firm Herbert Smith Freehills Kramer. We have Sarah McNally, who is a partner, and Sarah leads the global practice for insurance dispute at the firm, handling all aspects of major insurance claims for global policyholders. And I'm also really glad to be joined by Thomas McGarrett, who is a senior associate at the firm, and he advises on all aspects of insurance and reinsurance coverage issues for clients, including high-value property damage, political violence and risk issues, and trade credit. So in terms of our format for today, our speakers will present for about 45 minutes, and there'll be a chance for questions from you, the audience. Please send in your questions through the questions tab on the bottom right-hand corner of the Livestorm panel. And if you can just send your questions in the course of the presentation or anytime from then, I will post them to the speakers at the last 10-15 minutes. So we'll be looking forward to hearing from you. And also, finally, there will be a survey at the end as to your feedback for this session. We'll be gratified if you could fill in and tell us your thoughts. And that is also how you can request for the slides that you'll see today to be sent to you. So without further ado, Sarah, over to you.
Thank you very much. Great to have the chance to speak to you today. The work that we do in relation to political risk policies and political violence policies is really among the most interesting of the cases that we work on, because they often stem from events that are very much in the news, such as regime change or sanctions, or as a result of acts of aggressor countries. Now, although we're speaking about both political risk and political violence policies today, they are very different products. The sort of thumbnail sketch is that political risk policies concern losses which can happen when governments act in a way which deprives the insured of its investment. So typically, perhaps where a global entity has a subsidiary in another country, which we refer to as the host country, and that host country deprives the insured of that subsidiary or investment by an outright taking or making continuation of the enterprise impossible. Also within this bucket are actions by the insured's own government that can mean that they have to pull out of the host country as well. At the other end of the scale, political violence policies tend to be concerned with acts of usually groups of individuals with some form of political motivation that causes damage to assets. So they are very, very different in terms of the kind of risks they're looking to cover, albeit there are areas of intersection, and sometimes policies do have both covers incorporated into them. And indeed, some policies exclude what might be covered by the other type of policy as well. What neither policy will tend to cover are matters which are political in the broader sense of the word and don't fall within the kind of categories we're going to talk about. So, for example, the fact that there's been a general change in tariffs or taxes or government approach that might lead to a particular country becoming unattractive for your investment is unlikely of itself to lead to triggering the policy. Now, obviously, insurance policies range hugely from the extremely sophisticated sort of financial lines and cyber policy to much shorter form sort of marine type policies, for example. These policies are quite complex. They're often quite long. They have quite complicated triggers and exclusions and tend to have a lot of terms and conditions. So we're going to be looking to run through some of those and how they may arise and what you need to be looking out for at the placement and claim stage. To add a sort of extra level of interest, there are almost no reported cases under these policies. They tend to have arbitration clauses and be resolved confidentially, and so there's almost no precedent. But we will, where possible, talk about anonymised examples to illustrate the points that we're making. So Thomas is now going to lead off looking at the principal covers under the political risk covers.
Thanks, Sarah. And you'll see the first slide on the screen that we have here is to introduce the topics. And if we start in the middle, we have confiscation, expropriation, nationalization, and deprivation. And these are called CEND covers, as they're known in the political risk insurance market. These are all different ways to describe a taking by the host government. A typical example is where a global entity has invested in a range of subsidiaries and is forced to exit, leaving a foreign subsidiary behind. This doesn't necessarily have anything to do with physical damage to assets. To the contrary, it is often, but not always, where the host government is itself taking the assets. So if we then move down in the slide, you'll see currency inconvertibility to the left. Typically, this applies to interruption of scheduled interest payments or repatriation of capital, or dividends due to currency restrictions imposed by the host government. Effectively, this covers acts of the host government which block the relevant local entity from converting or sending money abroad. Money remains trapped in jurisdiction as a result. Below those, you'll see non-honoring of an arbitration award against a state entity. This is often an additional cover to political risk policies. It might seem like a wholly separate policy or risk, but it is connected. If a global entity brought a claim against a host government for, in effect, a taking, but the host government does not pay, then the policy would respond. While it might therefore seem very different, it's a different way to get protection from host government takings that involve bringing arbitration against the host state first. And as Sarah mentioned, if you then look to the top right of the slide, we have political violence. This is a very different cover. This protects against losses caused by war, civil disturbance, or terrorism. It's usually limited to politically motivated violence, but can mean sabotage, terrorism, civil war, malicious damage during the disturbance of the public peace. And critically, this results in damage or destruction in physical assets. And then on the bottom right, we have license cancellation. This deals with situations where the insured requires a license to operate from the host government. In effect, you have a license which is required to perform a particular activity in that jurisdiction, but that license is then removed. And so moving on to the next slide, we see this effectively, what we want to cover here is how are the policies structured. So you have typically an insuring clause, tends to be quite complex and multifaceted, as Sarah mentioned. There are a number of key concepts to bear in mind when you're looking at this type of cover. First is that there has to be an act by the host government. This can raise some tricky issues as governments act through various entities, so from its obvious face to the courts, regulatory bodies, the police. Next, the act has to be in the nature of a law, order, decree, or administrative action. And note here, governments often act in a contractual capacity, especially through delegated bodies, and that won't usually be covered, and there may often be express exclusions to that effect in the policies. The next concept to bear in mind is it must also be a CEND act. These terms are not usually defined, and so there's room for argument as to exactly what they require. Sometimes it will be entirely obvious that there's been an expropriation, for example, where the host government nationalizes a plant or imposes a sanction on a particular entity. However, in other situations, it may be much less clear. For example, the government's courts or police act in a way to minimize the value of the plant. The government by passing laws, the courts by upholding them in a particular way, for example. So that's something that you need to bear in mind, that it's not always as clear cut, and where you have these more complex situations, it can be quite nuanced and fact dependent. The third point is that there must be a permanent deprivation. So this must deprive the insured from a shareholding in its foreign enterprise or fixed or current assets, or alternatively B, it prevents or restricts operations so as to cause permanent cessation of the business. Depriving the insured of a shareholding may be straightforward if the government simply transfers them. Again, this may be more difficult if the government acts in such a way as to stunt the operation through regulation. Therefore, the deprivation will be connected to the proof of the relevant act. However, as I mentioned earlier, there's another way, and that the government acts prevent or restrict operations so as to cause permanent cessation. The issue here is often showing that there is cessation and it is permanent. This again is going to be very fact dependent. However, it's likely won't be enough that the operation becomes more expensive or more difficult or less attractive. It has to actually cause cessation. Basically, it can't continue to be operated. And as I said, this must also be permanent, which may or may not be defined in the policy. And where it is defined, permanent as in a capital P, this is often tied to a waiting period to see how matters developed. So the permanent cessation, for example, has to last for 180 days from the date of the insured event to see how things play out. It's only then that the loss crystallizes. And another thing to be aware of is exclusions. Typically, the policy will contain exclusions. So, for example, the one I mentioned earlier, exclusion for contractual disputes liability. A PRI policy will not usually pick up this type of contractual dispute between the host country and the insured. As mentioned, while it might be thought that it would be obvious when the government is acting as a sovereign or a contracting party, this is not always the case, and it's something that we tend to have to work through quite carefully. So moving on to the next slide, we focus so far on the acts being of the host government. That's true for C and D covers, and it's also true for selective discrimination. The key question here is, has the host government singled out the insured? In what way has it done so? So here there are various steps which you have to get through before cover can be picked up here. So there has to be a law, order, or decree by the host government as before. It has to be selective against the foreign enterprise, which is a key additional factor. So, for example, if there's a tax rise imposed on all entities, for example, that's not likely to be an example of selective discrimination, unless you can show that every entity impacted is in fact from one country and they've been selectively discriminated against. There has to be selective prohibition or restriction or prevention of operations or deprivation of shareholding or assets as before. And that then has to lead to the permanent cessation of the foreign enterprise before. And due to the overlap, this will often be relied on as an alternative to a claim for C and D covers. However, for some other risks, it's the investing entity's own government which matters. And forced divestiture claims are typical in this respect. So similar to the other heads, but here it's typically acts of the insurer's own government. Generally, it must be legally prevented from participating in the shareholding or benefits, or the relevant law, order, or decree expressly restricts or prevents the operation of the foreign enterprise so as to cause permanent cessation. That needs to be permanent and total cessation of the operation of a foreign enterprise. In effect, this is when the insurer's own government prevents the insurer from holding or operating the assets in the host country, for example, because it's against public policy. Classic recent examples stem from the sanctions regimes imposed by the UK, the EU, and the US following Russia's invasion of Ukraine, and which impacts the insurers based in those those countries and countries of the EU, providing investment or certain goods to Russia, which may mean that the insured's business can't continue. Again, threshold is high here, and it's not just based on investment becoming unattractive. There needs to be, as before, to be restriction or prevention. We've seen a number of claims arising as a result, and I don't think we're going out on a limb here by suggesting the current geopolitical climate that concerns regarding these types of issues are likely to be higher on corporate risk registers and are of greater relevance as a result to risk managers. Finally, that takes me on to forced abandonment. Typically in this context, there's a context of deterioration of conditions on the ground in a relevant area or region or country to the point where there's a need to get people out while you still can. You need to show physical abandonment of the foreign enterprise in circumstances beyond the control of the insured, and then as a result of three factors: a requirement or advice by the insurer's own government or official representatives to evacuate personnel from the host country or a particular area or region of that country. Two, you have a law, order, or decree with the force of law issued by the government of the host country. For example, the party's over, everybody needs to get out, and that's the order or decree that's come from that host government. And then thirdly, you have the outbreak of war, civil war, rebellion, coup d'etat in the host country, provided that such acts are liable to be harmful to the physical integrity of the foreign enterprise personnel. So what we're concerned with here are forced evacuations. The insurer's own government mandates that individuals should leave the country. Again, here, this can cause quite practical complications. Sometimes governments don't issue evacuation orders, but simply issue a message not to travel to a particular country. This can be an issue as to whether that will suffice. In addition, international investments can often involve individuals from multiple countries, and there may be an issue as to who's caught by the particular order. So therefore, if you're relying on this cover, make sure it's really clear that the relevant governments do in fact issue qualifying orders under the cover and how to approach the international aspect of your workforce. This whole area can be a source of real tension in cases where matters are heating up in a region or a host country and individuals are anxious and want to leave, but the strict policy requirements have yet to be met. So this can present real dilemmas to businesses where you're grappling with issues of safety of personnel, which are paramount, but you're also trying to make sure that you're covering off what needs to be covered so that you can access the cover. Moving on to the next one, and as mentioned earlier, we have license cancellation. So this is where a license is previously issued and valid, where there's no right to do the particular task or activity without that relevant license. Classic example where this cover comes into play is following a regime change, for example, in a mining operation in energy rich countries. The care here has to be taken. Cover will often be expressed in terms of cancellation and not the failure to renew. So consideration needs to be taken regarding the length of particular license as they're given and whether cancellation cover will suffice. And you may also have governments providing ostensibly justified reasons as to why they're cancelling, such as the conduct of the insured. So it may be necessary to look beyond the apparent reason given to cancel and then look to the true reason. And this can be quite complex and factual analysis required of that. But that is really what you're looking for, is what's the true reason for the license cancellation. And finally on the slide here, you see currency and convertibility. So that involves restrictions on FX currency exchange, which cause the inability to remit funds constituting dividends, for example, shareholder loan payments or intercompany payables or proceeds of sale. Cover for policy currency equivalent of the amount that cannot be converted or transferred based on the exchange rate at the date of loss. That's typically what the cover provides. And often you can see there's a requirement that the money has to be made available and ready to convert. You can sometimes see that you actually have to have attempted to convert the money, and there's a continued and unsuccessful during the waiting period, as mentioned earlier, which can sometimes give rise to issues in the policy. So have you continued to try, and have you continued to be unsuccessful for that whole period? So what this is really about is having monies trapped in the host country and being unable to remit it. However, again, this is quite a narrow cover. It's not about, for example, FX risk. And if the money is not available in the first place, then the policy is not triggered. A classic example here would be a foreign enterprise operating in a nation that's heavily dependent on income generated from its oil and gas sector. So in those situations where you have an economy that's primarily US dollar based, but the state requires the use of local currency for domestic payments and transactions. Take a classic example there where the market fluctuates and the oil price tanks. This can result in acute shortage of foreign currency reserves. So when this happens, it can give rise to government restrictions being imposed on conversions from local currency into US dollar, or the transfer of the US dollar out of state. And so that's the type of situation where this cover can come into play. And so with that, I'll hand over to Sarah to deal with terms and conditions next.
Yeah. Thanks, Tomas, for running through those heads. And so as you can see, there is a real political overlay, both in terms of what is happening in terms of the regulatory and legal position of the host country, but also potentially of the insured country, which, as Tomas said, that there may be more than one country that has an interest in the insured's investment. So there's quite a lot of political overlay. And there's a theme here which we'll bring out a bit more in the examples as well, that you have to look at what is actually happening as opposed to what it is said to be happening. Because obviously these days anyway, it's very rare for there to be anything that really looks anything like an outright taking. All political risks tend to materialize slightly more through incremental steps and steps of different bodies adding up to an expropriation, for example. And so there is a real political overlay and a real need to understand what's happening in the country and what's really happening, as opposed to necessarily what the news might tell you is happening. So all of that means that the words on the page suggest that these tests are sort of all fairly sequential and fairly straightforward, but in practical terms, they're often not, because you need to understand what's really happening on the ground, as opposed to perhaps what people are saying is happening. So I mentioned these policies were quite lengthy and had quite a lot in their terms and conditions. So I'm just going to touch on some of the key points that we look at when considering these policies. So assuming we're under English law, then the first port of call, of course, is going to be the duty of fair presentation. Now, that's obviously a very important issue for all insureds in all policies, but it can be quite tricky in these kind of policies. I mean, as an insured, you're probably looking at this cover because you do have some possible reservations about the jurisdiction. It's not like sort of taking property damage cover where you probably take that globally. You probably are looking for some of these covers in particular countries because you do have some reservations. You may be new to the jurisdiction, or you may have had years of experience in that jurisdiction, including possible regime changes. You may, if you've been in the country a long time, you may have had various governmental interactions, for example, in relation to previous licenses, or in relation to security of the plant, or your experience of the judiciary in that area. There may be all kinds of different experiences you've had in that jurisdiction, and which you'll have to think about when it comes to the duty of fair presentation. We do see, for example, that often when a claim does arise, insurers look to go back quite a bit before the immediate triggering event and really look back at the history of interactions with the government to see if there are matters which they don't think were fairly presented to them in terms of the interactions with the host government. And one of the biggest issues which we see arising here is a possible disconnect between those that have the real knowledge on the ground and those that are looking to work on the policy, whether that's in-house legal or the insurance team. And it's really important to make sure that all the relevant people are brought into that camp, understand the test under the policy, and that the legal and insurance team understand what's happening on the ground. Because generally, obviously in some financial lines policies, you have very, very generous improvements to the duty of fair presentation clauses in policies. Generally, that might be slightly harder to get in these political risk, political violence policies, where insurers generally are looking for information from the insured and won't necessarily waive remedies. So that's one area to really pay attention to. Warranties and conditions precedent, again, those are now sort of largely absent from many product lines, but we do still see them in these policies. And they may be on quite important issues. Confidentiality, for example, is often seen as important because insurers don't want counterparties, governments, etc., to know there's political risk insurance in place. So there can be quite onerous clauses in relation to that. Equally, one of the examples Tomas is going to speak to a bit later is around, for example, the security that's afforded to a plant. Sometimes some very, very detailed questions are asked about that. And these policies are not always annual, they might be 3 yearly. And so there might be issues about any changes that have happened. And again, it really makes it so important that there's a real connection between those on the ground that are running the investment and what's being said in the policies. And of course, to the extent you can remove the warranties or condition precedents, that's ideal, but you may find that you can't do that entirely. When it comes to claims, of course, again, notification is paramount in all policies, but again, in contradistinction to, say, a fire, where it's obvious the day that it happened, for these types of risks, it may not be entirely obvious when the claim has happened, when the policy has been triggered. And so issues of alleged late notification do arise. So again, what's really important here is that those on the ground that have the direct knowledge of what's happening are fully aware of the notification provisions in the policy, and there's a really good dialogue to make sure that nobody falls foul of that. Tomas mentioned the waiting period. So in addition to making a notification, that most of the policies will only provide for payment after a waiting period has expired. As he said, that might be around 180 days, it might be a different period. But the idea of this is it also ties into the question of permanence, that insurers are not looking to cover transient events or events which might be reversed the following week. They're really looking to see that this investment has in fact been lost. And so they're not looking to pay out as soon as something dramatic has happened. They want to make sure there is no practical way of getting it back. And the waiting period is meant to really be a bit of a compromise on that, because it's quite hard for insureds to prove a negative that, it's never going to be possible to reverse this. So the idea of this is to be a bit of a compromise, that insurers won't pay straight away. They want to see that it really is a major problem, that it can't be reversed, that it can't be improved upon. But then if you get to the end of the waiting period and it hasn't, hopefully your policy wording will then have some wording that makes it easier to show the permanent cessation, that if you haven't been able to restart in that waiting period, that it's then deemed permanent. But there's a very important interaction there. And as I say, it's really that balancing act of insurers wanting to know that this really is a permanent problem, with the fact that an insured obviously can't prove a negative. So again, a very important area to think about. Dispute resolution, as I mentioned, don't really have court cases, so typically it will be arbitration. So important to review the arbitration clause carefully, make sure that it's suitable. If you've got multiple insurers on the risk, make sure that as an insured you can consolidate the arbitrations if you need, so that you can bring one arbitration proceeding. and making sure you're comfortable with the applicable rules, whether it's ad hoc or institutional arbitration, number of arbitrators, etc. So for those that are more used to seeing High Court of England for dispute resolution, obviously look out and make sure you're comfortable with the arbitration provisions. Quantification of loss will depend on the kind of policy and interest. So, for example, for the equity investors, which is a fairly sort of standard policy, then entities insure their equity interest. So there will be a explanation in the policy of how you calculate that based on investment made and repayments made, and it will be fairly prescriptive. It will be necessary for the insured, with the assistance of an accountant, to go through and identify all the various steps. But it's basically looking at what money has been lost through this investment. What it generally won't be doing is providing a sort of business interruption cover that we expected to make this much profit over the next 10 years, and we've lost that opportunity. That won't generally be the way that loss is quantified under that kind of equity investor policy. It will be the money we have lost because that subsidiary is now lost to us, rather than on a future loss of earnings basis. Another quite common form here is the lender form wording. So this is where a lender takes out this policy in relation to the debt owed by the borrower. And so for this kind of policy, again, it's a very specific calculation. It's what repayments should have been made by the borrower, but haven't been made by the borrower because of one of these political risk events. So it's for the lender to protect the loan repayments that should be made by the insured, but can't be made because of the political risk event. Now, one point that I wanted to just mention here was that while you may have a claim under a political risk insurance policy, the same sort of situations may give rise to investment treaties. And so both claims should be considered together for you to get sort of maximum benefit from it. So under investment treaties, which might be bilateral or multilateral, in effect, an individual in state A enjoys protection from interference with its rights by state B. And if state B does interfere, then A has a claim against state B under the investment treaty. So you can see here this diagrammatically that you've got state A on the left and state B on the right. And obviously there's a relationship between citizens in state A and citizens in state B and state B under national law. But the red dotted lines show that the citizen in state A has a potential recourse against state B if they're investing in state B and state B has breached the investment treaty rights, and the same in the other direction. So it potentially brings into proximity an individual from one state and the state where that individual is investing, and provides recourse. Now, these claims are important, and often the clients do have both a claim under a political risk insurance policy and an investment treaty. You obviously have to look at both claims to see which is more advantageous. Investment treaties are effectively based on fair and equitable treatment of citizens from other states. And so, for example, expropriation without compensation would be something that would potentially trigger a breach of many investment treaties. So the same kind of facts which can lead, let's say an expropriation, that can lead to a claim under a political risk insurance policy may also lead to a claim under an investment treaty. And looking at both forms of recourse is important. This is also important from a subrogation perspective, because let's say an insured decides the political risk insurance policy is the better way to go, that's the better recourse, then insurers may well be able to subrogate to the investment treaty arbitration claim. So even if you're thinking the political risk insurance policy is the better way to go, it will be important to preserve those rights under the investment treaty so that you've complied with your obligation to preserve subrogation rights. So we're moving on now to political violence. So as mentioned, these are very different policies. And what we're concerned with here is physical loss or damage generally. Obviously, it all depends on the wording. But as Thomas said, that's often not needed for political risk and indeed may not be relevant because what may have happened is the plant or the investment has been taken. Nobody wants to damage it at all. They want to take it. But here you tend to be concerned with physical loss or damage. And it will tend to set out the particular risks that need to have covered that. So, for example, war, civil war, strikes, riot, insurrection, terrorism, most of which will be defined and will tend to have some sort of political motivation, although some less than others, and there will be often very detailed definitions. Terrorism often has a very particular definition in terms of acts of force or violence for political, religious, or ideological purposes to influence governments. So there'll be some sort of very specific criteria and buckets in order to trigger this policy. And there will generally be exclusions for matters such as theft, looting, unexplained disappearance. So insurers here are looking to cover, again, like the PRI, it's quite a specific policy. It's for this generally physical loss or damage caused by one of these politically relevant events. Now, one of the things we do see is that sometimes plant can be lost to the insured. So, for example, in the middle of a war zone, but they may not necessarily, it may not have been physically lost or damaged, or they may not know if it has been physically lost or damaged. So if you imagine one of the scenarios Thomas mentioned, where, for example, there's an abandonment of the plant, will they know what's actually happened? And we often find that's obviously an issue insurers often don't have to deal with because they often know exactly what's happened to an asset. But here you may genuinely not know. So you sometimes have to be a little bit creative. You have to think about whether you can get access to radar images, to kind of global images. You may need dedicated investigators who have people in the ground in hotspots. So there's quite a lot around the question of proof, which will need to be thought about in these policies. And many of the issues that I mentioned on the T's and C's will also apply here. So when it comes to the duty of fair presentation, for this kind of policy, insurers may be quite focused on the protection of the plant. So what your protection, what your guards are like, what your alarms are like. And so that, again, can trigger some quite detailed requests for disclosure, which need to be very carefully answered. Now, we said at the start that there are almost no reported cases. However, there is one on political violence that was this year. So it was Hamilton and Afghan Global Insurance. And so this had an insuring clause. You can see on the left, policy indemnifies the insured against physical loss or physical damage caused by one or more of the following perils. And you've got act of terrorism, sabotage, riot, streaks, civil commotion, malicious damage, insurrection, war or civil war, etc. So you've got physical loss or damage caused by one of these heads of loss. And you have an exclusion against seizure, confiscation, nationalisation, etc., loss or damage to the buildings by law, order, decree or regulation. And so you can see in that first exclusion a number of the buzzwords that Thomas was talking about that positively are covered by a PRI policy. What you can see here is a political violence policy saying we're not going to cover you for this seizure, confiscation, nationalisation, requisition, expropriation. And this is one of the issues that if you're looking to cover off both political risk and political violence, you need to work with to make sure that together you've got the cover that you need. So this was a reinsurance case, but the facts are instructive, and the loss concerned warehouses in Afghanistan operated by the ultimate insured. The warehouse was seized by the Taliban and the insured lost possession and control. So there were two issues of interest to us for the purpose of this morning. Was seizure by the Taliban, as opposed to a governing authority, insured? And was it enough that the warehouse was lost to the insured but not physically razed to the ground? So was seizure by the Taliban insured? The argument here was that the exclusion for seizure was only seizure where it was caused because of law, order, decree, or regulation of the governing authority. So in effect, using the first two parts of the exclusion together to say what's really excluded is seizure by a government. But the court said, no, that's not what's excluded. What's excluded is seizure. Whoever seizes it, it's excluded. And therefore, if it's excluded by the Taliban, it's excluded. It doesn't have to be seizure by a government. So that was the first issue. And then in terms of the second issue, which is the requirement of physical loss or damage, the court referred to case law, which defines damage as a changed physical state, the whole stream of authorities talking about what is and is not damage. But they found that this policy against physical loss or physical damage required a changed physical state, and that wasn't alleged here, that when the deprivation happened, it wasn't argued that there was physical damage in that sense, and therefore there was no cover. So I think it's an interesting example because it just helps show, with the exclusions, it helps show the political risk, political violence demarcation. It helps show how those words are used in an exclusion to a political violence policy. And it helps show how a court has construed physical loss or physical damage in that particular policy. We've obviously since had the AerCap judgment and issues about different wording and what you need for loss or damage, but physical loss or damage, this case will no doubt be referred to by others in similar situations. Just finally, before we leave this, we're obviously here talking about sort of freestanding policies, but many insureds will have some form of terrorism and political violence cover in their own policies, their property damage policies, etc. The key issue will be to look at how that is defined, how narrowly it's defined. So terrorism can be quite narrowly defined to effectively be talking about attempts to overthrow the UK government rather than this sort of wider bucket. So really looking where you've just got it as part of a general policy, really understanding how wide that goes is very important. And the second point, which is really important, is how cyber cover interacts with this. So we've talked so far about sort of very physical acts here, but of course, what most people are concerned about at the moment is sort of cyber and how that interfaces. So you need to really make sure, if you're looking to insurance to cover off your political violence type cover, your terrorism type cover, you need to make sure that you've also thought about how cyber interfaces with that. So are there any cyber exclusions which would undercut that cover, where you've got both a terrorism or political violence element and a cyber element? So as always, it's an intellectual exercise to try and make sure that you are covered for what you think you are. And of course, as always, scenario planning is the best way of doing that, to make sure that you've thought through in a scenario what may happen, what's likely to happen, what could happen, and you know whether or not you've got cover in those situations is key. So for the final few minutes of this morning, we were just going to run through a couple of anonymized examples just to hopefully bring to life some of the concepts we've been talking about. So the first one I wanted to talk about was just move this slides on. Sorry. Yes. So the kind of issues that we're going to tackle in the examples is what is expropriation? Does it include creeping expropriation, so multiple incremental events? When is there a permanent cessation and how do you prove that? What is the law, order, decree, etc.? Which government was required to administer it and which did? Notification and document requests and what can go wrong there? Who the insured is and who suffered the loss and what can go wrong in relation to that? The point that Thomas mentioned about mitigation and due diligence in dangerous areas where you're concerned about wanting to abandon on the one hand and requirements of the policy. The duty of fair presentation, which we've talked about. and limitation that obviously, if you've got non-English law, making sure that you don't fall foul of any limitation provisions. So in terms of the examples, the first was an equity investor that had a policy for assets in a host country. It was a local power project, and there was a JV between the insured and the government entity. And what happened was that the host government made life more and more difficult through multiple different routes. So the government had a contractual element as well, which, as Thomas said, won't be covered by these policies. And in its contractual element was being uncooperative and was in breach of contract, making life very difficult for the local JV. Then the courts were applying the law in a way that made it even more difficult because they weren't assisting in relation to that contract dispute. Then a liquidator became parachuted in through various administrative powers, and the government took over the plant for a short period when there was a shortage of power. So you've got all of these sort of different acts. You haven't got any sort of outright literal taking. You've got all these incremental acts which basically denude the insured risk of really being able to operate. Expropriation claim, the policy responded to actions by the host government. That was fine because it was the host government that was acting in this way, but through all these sort of multiple different aspects. And it was a sequence of acts, and that brings forward that sort of creeping expropriation I mentioned. Does the policy only cover a go in and take, or does it cover the incremental acts? We would certainly say it covers the incremental acts, but you need to get to a moment where you say, okay, now it's expropriated, because you need to do that to trigger the policy, to trigger the notification, to prove the quantum of the claim. And where you have a government operating as a contractual party as well, then there'll always be a focus on that contractual exclusion, because it will be for the insured to show that these acts were as a matter of sovereign and not just as a contracting party or shareholder, because you have to show it's them acting through a law, order, or administrative action. Whether or not the taking over the plant was permanent was questioned, so we had to deal with evidence of that and show that there was no reasonable prospect of being able to get it back. And again, that's something that has come through in the AerCap judgment as well. So there's some possibly helpful commentary there if you're needing to prove that. And at the same time, there was a claim under a bilateral investment treaty, and that referred explicitly to creeping expropriation, which was helpful, and both claims were sort of advanced together and ultimately resolved. So that gives you a little bit of an insight into how these issues arise in practice. So Thomas, I think you're going to now speak to your example.
Yes, thanks, Sarah. So my example is on a political violence policy, and I acted on one of the rare cases where this type of policy came before the commercial court here in London under a war, terrorism, political violence wording. And so the claim related to losses arising from the rebel occupation and destruction of a large manufacturing facility in Aleppo, Syria during the Syrian civil war. And the structure of the placement that we had was for the Syrian facilities was to be insured by a fronting insurer based in Lebanon, and then you had reinsurance placed into the London market. And given the volatility in the region at the time of the Arab Spring, this was only a 70% of 100% reinsurance available in the London market. So just to say that this was a borderline risk at the time, the situation was quite uncertain, and a lot of reinsurers weren't willing to touch that type of risk at that time. But they did obtain reinsurance cover. And so for that, the claimant had filled out a proposal form, which contained a number of responses regarding ownership, the makeup of the facilities, and critically security for the facilities. They were also required by the coverage terms to notify any material changes to the business operations, which would materially affect the insurance. And they also warranted that there had been no threats, incidents, or losses in the previous 5 years. And so, as Sarah mentioned, you can get asked quite difficult and detailed questions in the proposal form, and It's ensuring that those, to the extent possible, are answered truly and accurately. So in that proposal form, the insureds stated that there had been 2 armed guards protecting the facility. In fact, it transpired that the claimants had formed an army corps, effectively a private army corps of 240 to 350 armed guards to protect the facility on a 24/7 basis in 2 units round the clock. The original prop form also listed a family patriarch who was closely connected to the ruling regime as an owner. That was subsequently deleted and removed from the proposal form, which was submitted to the reinsurance market in London. And that all came out in disclosure. And the reasoning behind that was that they were worried that this person could become a sanctioned individual. So in fact, it turned out that there had been a number of non-disclosures and misrepresentations prior to renewal and prior to the notified loss. So when you work down through the examples of what actually happened, there had been sniper fire on the highway between Aleppo and the facilities, which had prevented employees from attending the facilities to go to work. This resulted in a number of what was called administrative holidays being declared for security reasons. That wasn't declared at the time. You also had skirmishes with rebels near the facilities, which ultimately on one occasion resulted in rocket damage to the roof of the facility. That wasn't declared either. And so following a deterioration of conditions at that time, so you have this skirmish near the facility, but not a taking of it. You also had a stockpiling of raw materials at the facility because it was difficult to get materials in and out. And that effectively was said to amount to making the facility a more attractive target because if there's a full stockpile of materials there, should it be taken. That also gave rise to underinsurance issues. And so following renewal, but prior to notification of the loss, the claimants had dismantled certain plant and equipment and shipped it to an alternative location. So it inferred that this was as a result of the civil unrest in Syria at the time, the war, and effectively the insurgents getting closer and closer and closer to the facilities. But none of that had been declared or notified through to insurers prior to the actual loss notification. And that kind of gives you a snapshot of the examples of the types of issues that can arise. And also it gives you a good indication of where something has been put in the proposal form as to no known threats, losses, or incidents. The example of 2 armed guards rather than the full corps of 240 to 350 at any given time protecting the facility effectively gave a very different view of the risk to the reinsurers in the London market. And when all this came out in disclosure, the matter ultimately settled on confidential terms. But that should hopefully give you an indication as to the types of ways you can get tripped up on these types of policies if you don't declare the matter truthfully and honestly at the outset of the cover being placed. So I think that was my example, Sarah. I'll pass.
And the final point, just to note on the examples, is with the abandonment, which Thomas mentioned, we have had cases where there has been a sort of very international investment and where showing that the insured's own government required everyone to leave the country has been quite difficult because that country didn't tend to give those instructions. They tended just to advise against travel. And equally, if you've got people from multiple jurisdictions there may be a question as to whether each of the governments need to require their individuals to leave. So there's a little bit of working out on that forced abandonment to make sure that you've got the structure as good as you can to cover who's actually going to be there. And you've covered off if they don't actually say, come back, they just say, it's too dangerous to go there. They sort of assume people will come back.
One final practical point actually on my thing, and it relates to something that you raised earlier, was given the nature of what was happening in Syria at the time, loss adjusters clearly weren't able to get in and see what was happening there to prove what exactly has happened to the plant. Actually, what transpired in that one was locals uploading videos to YouTube was able basically people driving by, showing what's happening on the ground. So as Sarah mentioned, you need to get quite creative in trying to figure out how can we prove there's been a loss here? Has there actually been physical damage to the building? But through YouTube videos, you can kind of see the shelling of the outer core of the building. So that helps you get over the first port of call there. And thinking creatively, as Sarah mentioned, is something that's quite important in these types of issues where you don't have neat and fast type claims.
Yeah. So I mean, it's an incredibly interesting area, and we see insurers making very good recoveries under the policies, but you do need to take some care at the beginning and make sure you've really understood the risk and really understood what you're getting cover for, and that is what you want. And at the claim stage, and it does require a little bit of patience to maximise these, but we've certainly seen clients get very good recoveries under them, and they obviously are hugely important and helpful to facilitate investment in emerging jurisdictions and in jurisdictions where people may have concerns. So hopefully we've helped give a little bit of a footprint of the things to think about in order to make sure that you have best benefit. And I think hopefully we've been able to cover off what political risk and political violence policies cover, the triggers, how losses are calculated, and the kind of issues that can arise. So I hope that has been an interesting summary. I think you've got our details at the back of the presentation. If anyone has any questions they'd like to raise or any discussion they'd like to initiate offline, please feel free to drop us a line. But I will now hand back to Ho Young, I think, to close the session.
Yes, thanks very much, Sarah. Thanks so much, Thomas. We do have about 4 minutes left, now 3. We got one question, if you still could take this quick question, Sarah or Thomas, from our audience, which is that under PRRPV covers, are there any obligations on the insured in the policy to keep it confidential or not to disclose its existence? Maybe just a quick question to close with.
It's a good question. Quite often, yes, there is an express obligation of confidentiality, certainly on political risk. Mainly my understanding is because insurers don't want the government to know there may be some sort of recourse in the event of activity. So I would expect to see some sort of confidentiality provision there. I wouldn't see it so much in political violence because that's not really targeted at the kind of people who might find out about the policy. So I wouldn't say I would see it so commonly there. You've obviously always got to keep an eye out, but definitely on the political risk, important to keep an eye out for that.
And just to add to that, it's not just that you keep it confidential while the claim is going through. There can often be a period of 2 years, for example, after the fact that a claim has been paid out, that you need to keep that confidential as well. So it exists beyond sometimes the period of the policy itself. For example, where you're running a claim, you've had a claim paid, and there's a period afterwards stipulated in the policy that must be kept confidential for exactly the reasons that Sarah mentioned.
Okay, thank you very much indeed, Sarah and Thomas. Please join me in thanking both of them for taking the time to speak to us on this very timely, very important, very pressing topic. And also, just a reminder to, if you in the audience could fill out the survey as to your feedback, your thoughts about this session, that'd be really much appreciated. And that is also how you can ask for the slides from our presenters today to be sent to you. So if you fill the survey, that'd be great. We look forward to seeing you at the next IMEC Academy. But thank you very much again, Sarah, Thomas.
It's a pleasure. Thank you. Have a good day, everyone.
Thanks all.
You too. Thank you.